What this court must decide is what the legislature intended 30 years ago when it wrote the removal or alteration of a serial number statute.
Minnesota's Supreme Court opined that the state statute didn't explicitly make the ownership of so-called ghost guns illegal. The decision stemmed from a case against a man named Logan Hunter Vagel, who was initially charged with possession of a firearm that didn't contain a serial number, one that technically classified as a ghost gun. In oral arguments a few weeks ago, Vagel's defense argued that the state law was meant to work alongside the federal law.
I think, you have a meritorious argument, certainly, that if you were to look at what the legislature did, it sort of mirrors the statute.
But federal law doesn't restrict the ownership of ghost guns. Therefore, the argument was that the state law on the subject wasn't meant to either.
The statute, read in its proper context, clearly effectuates the known intent of the legislature, which was to create a state crime that mirrors the federal law prohibiting the removal or alteration of serial numbers.
The state presented a different argument, that the law, while ambiguous, had a clear intent when written.
Anyone who reads that knows what is prohibited in the state of Minnesota. Minnesota law is more restrictive on this point than federal law.
The court sided with Vagel, but that's not the end of the story. Already, lawmakers like DFL Senate Public Safety and Judiciary Chair Ron Latz have committed to closing the ghost gun loophole next spring. It's not clear how much support the push would have, but GOP Senator Andrew Matthews issued a statement appearing relieved that Vagel's defense had prevailed. It's likely Matthews' statement was more so an expression of support for the defendant's situation than the issue at large. Reporting in St. Paul, I'm Quinn Gorham.